Good evening, guys. Today we are going to discuss another important topic, that is Foreign Contribution Regulation Amendment Bill 2026. Okay, you know very well there is an act, FCRA Act, Foreign Contribution Regulation Act. Okay, it is to manage or regulate the contributions that are coming from other countries into our countries, especially with respect to NGOs. Okay, many NGOs get foreign contribution. To regulate that, this act is there. Now, several important changes. Okay, some are changes and some, you can say, some additional voids or additional provisions are being added to the original act through this, or proposed to be added to the original act through this amendment. Okay, through this amendment, the amendment of 2026. Okay, very important aspects are there, and you have to know about very each and every one of them. It definitely could become a question in the upcoming mains exams. Okay, the present status of the bill is, actually government was very much adamant of passing it in the present session only, but finally it agreed to refer this bill to a parliamentary committee. Okay, so now the parliamentary committee will examine the bill, and maybe in the next session, coming 6 to 1 year, the committee may give its recommendations. Then once again the bill may be considered for passing, etc., etc. But remember, the provisions are very important and you have to know about them. Okay, right. So first we will see the background or evolution of the FCRA, and we will try and understand the context of the act. Okay, so the Foreign Contribution Regulation Act 2010 is there. It regulates how individuals, associations, or companies accept and utilize foreign grants and donations. Okay, you see, all this regulating the foreign contributions has had begun with this, you know, with the Greenpeace India. Okay, Greenpeace India, when it vehemently when this Greenpeace, which is a leading environmental organization, opposed the Udankulam nuclear power plant constructions. Actually, the plant is sponsored by Russia, and the parent body, the Greenpeace NGO, belongs to USA, and it's, what should I say, child body is there in India, and that is called as Greenpeace India. And in that context, the government of India has brought in this FCRA Act. Okay, right. The primary objective of the Act is to prevent the diversion of foreign funding into activities that are detrimental to national interests. So, in that instant, and in several other occasions, the government has seen that actually a lot of the foreign contribution is being used for anti-government activities. Okay, to conduct rallies against the government, to conduct protest movements against the government. That is what the government thought, and that was reflected in somehow it is reflected in the Greenpeace India's protest or movement against the construction of Udankulam nuclear power plants also. Okay, right. All participating entities must actively obtain an official FCRA certificate to lawfully receive any foreign contribution. So then the government has made it compulsory that all the associations which want to receive foreign contribution, they have to first obtain a certificate from the government. Okay, permission from the government that we want to utilize, we want to get foreign contribution, foreign funds, and utilize them. Okay. Then if you briefly see the timeline, okay, the 1970, earlier there is an act, okay, 1976 act. So the original regulatory framework, the validity of the issued certificate was completely not time bound. Earlier act means the act which was there before 2010, it just once issued the certificate, and there was nothing kind of mention of a time limit for that certificate. Okay, once the certificate is issued for receiving the foreign contribution, forever the certificate was issued. In the 2010 Act, there is a time limit prescribed, that is 5 years. Means once a foreign FCRA certificate is issued to an association or body, an NGO, it will be valid till 5 years only. After that, what will happen? You have to, if you still want to receive foreign contribution, you have to renew it. Okay, right? That was there. So the 2010 Act replaced the 1976 structure and introduced a strict 5-year renewable legislation cycle. Uh, Further, this 2010 reform also established a specialized prior permission route, specially designed to govern one-time recipients. You see, out of this FCRA Act, just once you want to receive foreign contribution, then you have to get prior approval from the government. This is one time, one time receiving the foreign contribution. Okay, not a repeated contribution, not regular contribution, one time. For that, prior approval route is allowed by the government. Means from government you get permission, get the grant, that's it, done. Okay, this was the mechanism. Right. We will move forward. Now we will see what are the changes. Okay. Sorry, we will see some of the facts about the foreign receival of the foreign contribution, the number of certificates, etc., etc. Okay. One important development was between 2019. Okay, between 2019 and 2012, India witnessed a massive flow of international funding under the uh, regulatory purview of the Ministry of Home Affairs. Means the ministry has noticed that a lot of foreign contribution has come into India. Several reasons can be there for that. Maybe because of the COVID-19, people wanted to help India because India was witnessing at the time things were precarious. Maybe people sent donations, maybe otherwise also. But you see, beyond a certain limit, if foreign funding is coming into India, you have to think about it. You have to see whether it is coming into appropriate things, or the money is used for good things. There are beliefs that earlier foreign funds were used to convert people from one religion to another religion. This was the biggest problem that the government has seen, that foreign funds were being used to convert people from one religion to another religion. Then some anti-social elements were also using it, and the money was used to just encourage anti-government or to promote protests against the government, etc. These were the concerns raised by the government. If otherwise the funding is used for good purposes, like to alleviate the poverty, to spend it for education, to use it for protection of environment, okay, then actually we should be not worrying that much. But the problem is when the foreign fund is used for unwanted things, then it will become a problem. Okay, so the total number of organizations that have received a foreign contribution between these years, okay, 2019 and 2022 were 13,520. The amount received is 55,000 plus crore rupees. So you have to say this is a very, very, very substantial amount. That's why the government is worried. Okay, if the money may be used for good things, the government need not worry. But the government somehow or the other, the government thinks that it is going into some unwanted things, like maybe promoting religious conversions, anti-governmental activities, etc., etc. That's why government is once again, especially the Home Ministry, waken up, and it's trying to make the things much more stricter under the act. Okay. Then if you see the data about the certificates, okay, so data from the FCRA portal shows that as of this latest date, July 15th, 2026, active FCRA certificates were 14,449. Cancelled certificates were 22,498, and 15,000 plus they have deemed expired. Means after 5 years have been completed and the people did not apply for renewal. Okay, and government has cancelled 22,000 plus certificates, which is a very, very substantial number. How many are inactive? Just 14,449 certificates are active now. So you can see very high. Roughly, this is 37,000 certificates are either cancelled by the government or they have expired. Okay, just 14,000 of them are now surviving. Okay, all right. We'll move forward. If you see some details, some more details about the 2026 Amendment Act. Okay, so the bill was introduced in Lok Sabha on 25th March 2026. Then several things have been put in that amendment bills. What are those? Okay, you see the certificate that allows for entities to get foreign contribution, it immediately ceases to exist. Okay, when an entity completely fails to renew its certificate before its 5-year validity expires. Okay, once the 5-year timeline expires, the certificate ceases to be exist. One important thing. Second thing is the amendment also seeks to govern defunct organizations through rigorous compliance, administrative, and auditing system. Okay, so the NGOs or bodies or associations which were earlier receiving FCRA funds, for example, they have stopped functioning. Then what we have to do with them? What is the future of them? Which the act also or amendment act also addresses those things. Okay, so to look after these defunct organizations, a body is going to be created under this particular amendment. Uh, a specialized designated authority is going to be created. A body, it will be a body. This will oversee the assets of these affected organizations, whether they are defunct, whether they have flouted the rules, their certificate stamps cancelled, etc., etc. To look after all these things, a specialized designated authority is going to be created under the act. Okay, so if you see this specialized designated authority's mandate, what it is going to do, it will take over non-compliant organizations, especially NGOs, associations, etc. The body will manage and maintain the remaining funds, okay, of the organization. It will lawfully dispose the vested assets that were vested in the particular body. Then it will also control the cancelled or surrendered entities, okay, to the to it. Okay, these are the mandate and functions of the specialized designated. Okay, further provisions, if you see, okay, under the proposed framework, under the present amendment, assets built or acquired using the foreign contributions will officially vest from once the body gets defunct or certificate gets cancelled. The the contributions, foreign contributions, will officially vest in the prescribed authority under the three distinct conditions. So what are the three distinct conditions? First one is surrender. Okay, so this is voluntary termination of the assets and the funds when an organization no longer seeks foreign grants. Okay, second one is the certificate is annulled by the central government due to regulatory violations. The body has flouted the regulations. Then the certificate stands cancelled. Then the specialized authority will take the management of the assets. Then third provision introduced in this particular act, that is automatic expiration of certificate if renewal fails or renewal is rejected also. Then the cessation of the property and funds will be triggered. Okay. Then the third provision is permanent vesting. Failing restoration, assets are liquidated and proceeds will be credited to the Consolidated Fund of India. So if the body fails to renew its certificate, then the authority can dispose of all the assets and the money will be credited into the Consolidated Fund of India. Okay, right. Then post vesting assessment and disposal. If you see that these vested assets must be designated strictly, okay, for public purposes only, and the designated authority holds a broad execution mandate to transfer or liquidate. Okay, it can continue the property or it can sell the property also, the specialized body. Okay, then the authority also may transfer vested holdings directly to other ministries, departments, state agencies, or central authorities. It can transfer it to other government agencies also. Okay, the assets can also be disposed via commercial sale. All sale proceeds and the remaining cash contributions credited to the Consolidated Fund of India. So money will go to the Consolidated Fund of India. Okay, if the asset is a place of worship, then some other important additional provisions are there. We will see them. You see, special protections and strict management guidelines apply if permanently vested assets comprise religious structures or the places of worship. Okay, so in that case, you see, the management must be entrusted to a prescribed person, ensuring proper local governance and a strict adherence to administrative norms. So the place will have its religious nature, and a person will be appointed to look over that religious or place of worship. Then it will be administered appropriately. Okay. The designated authority is legally bound to guarantee that the distinct religious character of the place of worship is fully maintained and it is not disturbed. Okay. Then prior, like we have discussed before, prior permission route and the compliance conditions. If you see that unregistered entities must obtain, means the entities which did not get this FCRA certificate or not registered in the government portal, they must obtain direct central government authorization before receiving any foreign contribution. Okay, so the funding is strictly restricted to a pre-approved specific donor source and must be utilized solely for the authorized purpose. It should not be. It should be used only for the mentioned cause and for nothing else. Okay. Then permission remains valid only for the specific financial amount or targeted objective originally declared. And so these are the conditions that will apply for the prior approval route for the bodies which do not have the FCRA registration or certificate. Okay. Then on this, the present bill has put some additional constraints also. This proposed amendment introduces stricter temporal limits to prevent indefinite holding of unauthorized foreign funds. So what are those? First is all received foreign contribution must be completely utilized within a strictly prescribed time frame as defined by the new rules. New rules means within the given time frame, the body has to utilize the funds. It should not delay the utilization of the funds. Okay, so unlike FCRA certificate holders, assets created via the prior permission route are not currently subjected to automatic vesting of automatic vesting upon expiration. So in case of the bodies which have FCRA contribution certification, if they did not utilize the foreign contribution within the prescribed time limit, the assets that were created until then will be vested in the specialized body. Okay, but that doesn't apply to the bodies which are receiving amounts through the automatic route. Okay, then if you see the key functionaries and the what should I say, penalties if anybody flouts the rules under the 2026 bill, criminal liability for organizational offenses shifts directly onto specially defined key actors like a key functionary is presumed strictly liable for any organizational offense unless they prove it occurred without the knowledge of the excess knowledge or they exercised due diligence. Otherwise, So the person who is responsible for running the body, the person will be strictly responsible to the mishap that has taken place. Second one is proof of systematic compliance and proactive governance service, the primary legal defense against individual prosecution. Okay, so the point here we have to take here is the person who is responsible for running the body, that person becomes whole and sole responsible for any mishap, corruption, misuse of funds, or anything that is going against the law. That person will become responsible. Okay, so the bill explicitly catalogs responsible officers and establishes post-closure notifications also. Okay, this includes company directors, firm partners, trustees, HUFs, Hindu undivided families, kartas, office bearers, and any managing or controlling authority. Okay, then last active key functionaries carry a statutory duty to notify MHA if the entity becomes a defunct. So the person who is responsible, last person who is responsible for running the body, if the body becomes a defunct, that person is legally bound to inform MHA, Ministry of Home Affairs, that the body has become defunct. Okay, so failure to notify this thing triggers permanent vesting of all foreign funds in the designated authority, special designated authority. Okay, right. So these are some of the important changes that have been proposed. Okay, so maybe in another video, I will try to do a deep analysis of the provisions. Okay, deep analysis of the provisions. What is going to be the impact of these provisions, or how they are challenging? These all new changes are challenging because many of the NGOs, especially the religion-based NGOs, they got alarmed. Especially the NGOs belonging to minority communities, they have given a lot of flooded the MHA with lot of representations, and because of that reason only, the bill has been referred to a parliamentary committee. The committee will examine. Anyhow, we will deep dive into into the provisions, and we will do a detailed analysis of what is the greater impact of these provisions. Okay, that we will do in another separate video. Okay, so this is it for today. See you next time. Until then, have a very good time.